Thank you. And let's get started. So welcome to part one of the mediation in the patent and technology case, what we call Ready, Set, Go. I'm joined this afternoon, at least this afternoon here in the Bay Area, by three very capable and personable colleagues. I have Harry Sabaris and David Allgaier, who are, like me, members of the Silicon Valley Arbitration and Mediator Center Tech List. We are joined by Janet Martinez, who is director of the Gould Negotiation and Mediation Program at Stanford Law School. Our bios are in the materials, so you should have had a chance to see those if you'd like. Suffice it to say that all four of us have deep experience in mediation, and hopefully we can share some of that experience with you this afternoon. Harry, David, and I all started off as commercial trial lawyers, specializing in IP and patent cases over the years. We gradually shifted to more of a role as neutrals, arbitrators and mediators. And now, Harry and Dave are both full-time arbitrators and mediators, and I'll soon follow their lead at the end of this month and become one myself. Janet has had a distinguished career as a mediator and trainer, and is now on the academic side running the Gould Center and teaching. Now the four of us have divided up our topics today by slides, and you'll see our faces ping-ponging back and forth and addressing the different issues. There's no particular order to that, so don't try to figure one out. My role is right now to give you a short introduction of what lies ahead. And let me give a couple of introductory notes to that end. First, on procedure, you'll see at the bottom of your screen, if you're not familiar with it already, that there's a question and answer module. You can ask questions at any time you'd like, and we'll do our darndest to get to all the questions we can during the broadcast today. We're also going to use polling questions, and we'd like you all, as much as you would want to participate, so we can have an interactive and proactive element to this program, and we can get some feedback from you on the fly. Second note is on substance. This program, as well as the program on Thursday, 2 days from now, is based on a fact scenario, what we call the case of the lost licensee, and we can thank Dave Allgaier for that. We're going to use that hypothetical fact scenario to illustrate various points we make today and Thursday. And the case of the lost licensee will show up in polling questions as well. Today, we're dealing with the nuts and bolts of pre-session preparation and strategy. This is all part one. It's all pre-mediation session. And then on Thursday, we'll shift over to part two, which will focus on mediation, the mediation session itself, as well as effective advocacy. So let me give you a short preview of what lies ahead today. We'll start off with some more detail about this case of the lost licensee to remind you, if you've already read it, and to refresh your memory of what lies ahead. Then we'll turn to mediation timing. Obviously, what time is right for mediation will depend, like a lot of things in law. We'll talk a little bit about what goes into the timing. Next, we'll turn to choosing the right mediator. Obviously, an important consideration and decision to be made in any mediation. And again, it likely will depend on a lot of factors that meet the needs of the specific dispute. Then we'll talk about planning your approach to mediation. And the success of a mediation really does depend on planning. One of the themes you'll hear again and again today is that pre-session planning and preparation is essential to success in mediation, and more time should be devoted to preparation. That includes pre-session preparation of the mediator, him or herself. You need to give the mediator the information and the tools he or she needs to be successful. Remember, you know your dispute, you know your client, you know the dynamics. The mediator won't know that. You'll have to help him or her learn. Then we'll turn to planning the mediation session itself. Such things as, do you want to go online, as we are right now, and as I think most mediations will have to be in the foreseeable future? And if you do go online, think about some of the challenges and opportunities that presents to you. We'll talk a little bit about protecting confidentiality. My own view is that confidentiality and flexibility are the hallmarks of mediation. They're what really make the process work, and therefore it's important to protect confidentiality. Then we'll talk about joint sessions. Do you want to have a joint session? You just can't show up at the mediation session itself and determine then whether or not to have a joint session. You need to plan ahead. You need to make sure you think about it. You talk to your client, you talk to the mediator. You probably want to even talk to opposing counsel to make sure that your signals are all straight and you proceed together with the same plan for the joint session or not. Finally, you should think about, what will a settlement look like? Mediators are optimistic. They hope to resolve the case, but they're not going to be able to resolve it unless you provide them with the tools, with at least a form of agreement that can be used to finally resolve your dispute. Then we'll finally turn to putting all of that together, and we'll turn back to the case of the lost licensee. And I'll turn over to Dave Allgaier now, who will talk a little bit more about that case.
All right, well, let me tell you a little story. This is the case of the lost licensee. Hopefully you've had a chance to look through the text that we sent you that has a little more detail, but here are the basics. The parties, we have the plaintiff, PL Industries. That is a software licensor. It develops software that's used in machine vision systems, which are used in manufacturing. It licenses on a non-exclusive basis this software to the defendant, DEFCO. It gets 10% on products incorporating the software, not just the software, but sales of whole systems. It has 2 patents on the software, both of which cover what's called data flow computing. There's a question as to exactly what that means, which we'll get into in a minute. One of the patents focuses on software claims, just the software. The other is using the software in a system, including cameras and controllers and everything else. Then we go to the next slide and get to the defendant. And the defendant is DEFCO. Now, it provides machine vision systems which include the software. Well, you know, things were going all right for a while, but it then decided that it would avoid the plaintiff's PL's patent by redesigning the software. The patent, you see, DEF claims, uses the term data flow in the claims in a technical sense, which means it performs a computation when all operands, become available. They say it doesn't work that way. It doesn't use that type of computing. It uses regular computing. Yeah, it shows some maps of how the data flows, but it doesn't use data flow in that technical sense. So it terminates the license. It says, we don't need it. We don't do that. It also, for good measure, claims the patents are invalid because they're indefinite. If data flow doesn't mean the technical sense, then it just is not clear what it means. So it's invalid as indefinite. And also it says, I've been reading the cases. I know about section 101. You're just comparing 2 images. That's an abstract idea. PL, the plaintiff, of course, is perfectly happy to disagree. It says, look, this redesigned software is only cosmetically different. It's the same as it always was. You didn't redesign anything. You do infringe. You do need to pay under the license. And you hired away Betty Arnold. That was one of our software developers. And you hired her away. And she was instrumental in designing the software. So you took our trade secrets and other confidential information. And that upsets us. And so that results in a lawsuit that we'll be discussing later.
Thank you, David, for laying a foundation for us in a factual situation to reference. So the question to start with is timing the mediation. When should you think about raising the potential for mediation, exploring it with the other side and with your own client. The short answer is anytime. Mediation is a very flexible process, and one of its qualities is that it can be invoked anytime. So, but you say, well, how do I think about this? It's really a balancing between, do we have enough information to make a thoughtful and informed decision? Or do we need more time, more information exchange, documents, depositions, other means of information gathering that is going to put us in a position? So thinking, does mediation at this time move the ball forward? So if you've done an early case assessment, which Harry is going to talk about shortly, if you've done the early case assessment, one of the issues that you'll have considered is whether, what is your strategy for settlement? And so assessing whether there are barriers that have made direct negotiation infeasible or unsuccessful, then thinking at a number of triggers that might cause you to initiate mediation. So it certainly could, before a lawsuit or Section 337 is filed. It can be during a PGR process, during a trademark opposition process, after the lawsuit is filed on the main case, and run in parallel. So often when we talk about mediation as a form of ADR or alternative dispute resolution, often it's actually in parallel. So you have processes, both litigation, mediation, running simultaneously. It can be after a verdict is rendered, can be on appeal, can be triggered by certain case events like a Markman process or motions. So clearly it can be earlier or later, but really thinking about each early mediation also allows you the advantage of spending litigation dollars on the settlement. There are a couple other triggers. One is there may be just natural stages of the case. It may be that one party or both have signed the CPR pledge that commits their company to resolving disputes via ADR processes before they pursue full litigation. And it may be that things have changed and in-house counsel are getting pressure from the client or the business cycle or some other imminent effect that it makes sense for mediation to be considered. So many prompts, many possibilities. Do you have enough information to settle, or do you need some more, and do you need some help facilitating the conversation between the parties? Okay, David, you have a polling question for us.
All right. Let's assume that the damages in the case of the lost licensee, which we're going to get into this in more detail later, but right now let's assume that lower range of damages is about 1.3 million, and an upper range before trebling and all that sort of thing is about 3.3 million. What do you think would be the ideal earliest time to mediate this case? A, before the Markman ruling, B, after the Markman ruling, C, after discovery is complete, D, after the court rules on the parties' inevitable motions for summary judgment, or E, none of the above. And by the way, I might mention, this isn't one of the choices, but of course, one of the times you might mediate is when the court tells you you're going to mediate, which often happens. But that's usually closer to the time of trial. Okay, the polling is coming in hot and heavy. Okay, I think we've pretty much got the polling in. And I don't know if everyone can see the results or not. Let's see if we can share the results. All right, is everyone able to see the results of the polling? Okay, well, you all kind of agree with me, I guess. It seemed to be in a case of this size, while the damages are, I guess, substantial as patent cases go, when you're talking about this 10% royalty on the amount of sales you have, it really isn't a whole lot of money that can get burned up pretty fast. It might make a lot of sense, it seems to me, in this case, to go in before the Markman ruling. For one thing, the Markman ruling is pretty well going to be the whole case in some ways. Now, I imagine some might, if they were particularly confident in their position, might think, well, let's just do the Markman ruling. That's going to determine how things go. But if the parties are motivated to get the case settled, probably in this case, the earlier the better would be my thought. There's no really right answer, but earlier makes a lot of sense in this case, given the dollars involved, it seems to me, and the likely expenses. Okay.
Thanks, David. Okay, so if you've decided that you want to mediate, question is what kind or what style of mediation is going to be most effective for your parties and the issues at stake. So you have choices, different flavors of mediation, and you might want to be familiar with the different models so that you can actually inform your choice of mediation as a process. A facilitative model is really focusing on helping the parties clarify their priorities, their interests, what they're trying to achieve. Can also include really reality testing what is likely to happen in litigation, and therefore what are the kind of the boundaries that we might want to consider. But this is really a facilitative process. The third party neutral, the mediator, is really assisting the parties in counsel to have a more effective conversation. A more evaluative model, the mediator really evaluates the strengths and weaknesses of the parties' positions and gives them feedback on what's likely to happen given the facts and case that they have. A practical or hybrid model really takes the best of both a facilitative, evaluative combination that is more suited to exploring what's possible in terms of settlement. Headbanger, like it sounds, is a more coercive, more directive form of mediation. Some clients really want that and select really a more structured and pushed outcome. Transformative goes to the other end of the spectrum. In this case, the mediator is really focused primarily on the working relationship between the parties. So here is where you'll want to know, what does a good outcome look like? And if a good outcome involves damages, so some financial settlement, that's different than if a cross-license or continuing business relationship is a possibility. So if the latter, if there's an ongoing working relationship that is valued and could be fostered through this process, then a transformative mediation makes sense. And then as part of that overall focus on the relationship, to sort out the dispute itself. Okay.
Well, thank you, Jan. And the closely related question is obviously the mediator selection itself. When you decide what model you want to try to achieve with the mediation, how the mediator carries that out is going to have a lot to do with your success. This slide lists some probably obvious considerations that you may want to look at, attributes and characteristics of the mediator. On the left-hand side, it's really more experience related. And let me talk a little bit about the conflicts issue, because in mediation, you can waive conflicts. The parties can agree to anyone as a mediator. On the other hand, you probably don't want to have your adversary's law firm partner as the mediator. You probably don't want to have someone too close to it, no matter how much the disclosure is. The exercise of conflict disclosure is very important because you don't want to be surprised. You shouldn't have to learn later on that there is some close connection, some relationship between the other side and the mediator you were not aware of. Obviously, that would undermine your confidence in the mediator. Obviously, the mediator needs to be available. You want someone who's good, but not someone who has no time availability when you need them. You'll, of course, want someone who's got experience and training in mediation. There may well be relevant non-mediation experience, and this, especially in a patent and technology case, can be quite important. You might want to think about whether someone does have a PTO license, or someone is experienced in trying patent cases, or someone is familiar with the local procedure in the courts. You'll, of course, want to think about the record and reputation of the mediator and the knowledge of the relevant law. These are really pretty straightforward and obvious considerations when you're thinking of the right person. And I think, as Janice pointed out, really some of this will depend on what style you want, switching over to the other column. So if you do want a facilitative or evaluative person, that may not be a transformative mediator. It may not be a headbanger. Most mediators, I think, are pretty adept at putting on different modes for different needs. That is, you can be a headbanger some of the time in caucus and quite facilitative outside of that. But people have strengths, and you want to be aware of those strengths. You want to have a mediator who accepts input for designing the process. Remember, mediation is flexible. You're going to create a process that meets your needs. And to do that, you want to design it, and you're going to have to design it with the mediator. You want a mediator who uses the submissions. You're going to spend time putting together your mediation statement, maybe a confidential statement for the mediator. You want a mediator who actually reads those, understands those, and makes use of those. And perhaps most of all, you want a mediator who connects with the parties. It doesn't do a lot of good if only the lawyers like this mediator and are comfortable with him, if your client is not. So your client needs to get a rapport, and the mediator needs to be someone who can earn your client's respect and confidence. In that way, your client will confide in the mediator and hopefully reach some kind of position for facilitative settlement. The mediator also may need to work with the exchange of information. You aren't going to get very far if you are in the dark about each other's case. And the mediator more and more needs to manage the process. This has really been one of the ways the mediation practice has changed over the years. It's not just showing up at the session and trying to wing it. It's planning, it's managing, it's going through the steps pre-mediation to make sure you maximize the chances for the party's success. And you really, at all costs, as the mediator, want to ensure a fair process. You're not going to get very far if one side or the other thinks the mediator is not being fair and is not running a fair process. Let me segue to a different consideration. So now, how does this work practically? We kind of looked through all the characteristics and attributes, but how do you actually get around to choosing a mediator? Well, let me suggest one practice that I have and have worked on over the years, and that is really letting the other side provide input. So we're now at a stage in experience, I think, especially in a patent and technology case, where there are a finite number of very skilled and well-known mediators, and most lawyers will be aware of who those people are. So when you're deciding to mediate and you're talking to your opposing counsel, instead of saying, here is my choice, I think this choice is best for Mr. X, and kind of dictating it to the other side, right away you're into a disagreement. I found a good practice that I've used a lot is to go to the other side and say, why don't you, opposing counsel, think of 5 or maybe a half a dozen of suitable mediators you'd be comfortable with. Let me know those names, and then I will hopefully be able to select one of yours. I do that because if I can select someone chosen by the other side, that I think gives a little bit of an advantage, because the other side will have been vouching for the credibility and effectiveness of the mediator. And then that mediator is going to hopefully, if someone I can approve as well, will turn around and tell the other side what they really ought to think about their case, and perhaps suggest some means to resolve the case that the other side will listen to, more so than if it was my chosen mediator. Here are also some related myths that you might keep in mind or dispense with as you're choosing a mediator. A mediator is not going to take your side. In other words, a mediator is not going to come in there and say, I favor this side and I'm going to dictate a result. Mediators can't dictate results. Mediators can't be obviously biased. That would make them very ineffective. And the mediator who knocks heads, Jen mentioned this as an attribute, but I think it's really important that attribute can be turned on and off. You don't want someone who's just irascible and thinks that they know everything. That's not going to be effective. Mediators need to listen and understand the needs of both sides. And a mediator is not going to go back to your trial judge and spill the beans. That may be a fear. In some jurisdictions, I think it's basically non-existent these days. There should be an ethical wall between the trial judge and what happens in the mediation, because, as I've emphasized, what happens in a mediation is confidential and should stay there, and certainly should not be shared with the trial judge. And lastly, this last point is important, because you can't just show up at the session and say, let's start negotiating. Before a case is ready for negotiation, a skilled mediator is going to go through the process of listening, of flushing out interests, not just positions, but interests, of talking in caucuses, of really understanding the dynamics of the dispute before it is ready for ripe for negotiation. Now, one other practical issue as you're choosing mediators is, what are the sources? Where do you go for mediators? Really, the first three boxes here are all related to the courts. The first two don't give you a lot of choice. If the magistrate judge is appointed, that's your mediator. Most judges will allow the parties some input on that choice, but not all. The same with your judge's favorite mediator. This still happens in some jurisdictions where the judge will just appoint a mediator because he or she thinks that mediator is very effective. You may not have a lot of choice. There are court lists, though, and most courts with sophisticated mediation practices will have a list of experienced members of local bar who the court believes are well-trained and well-suited to handle disputes. You might want to look at that court list, and especially if the court is going to be assigning a mediator to you. Most courts also allow the parties to go off on their own and to choose a private mediator if that's what the parties can agree to. And that's the last box here. And that one, really, the sky's the limit. You can come up with anyone you want, but it's probably best to get someone with good experience, someone well-known to you and others in your firm, as well as to the bar generally. And for that, you may well want to turn to a provider, to JAMS, AAA, WIPO, or other ADR organizations. And to put a plug in here, the Silicon Valley Arbitration Mediator Tech List, that's SVAMC, is another good source. As I mentioned, David and Harry and I are all on there, and I think there's some very, very good people who are experienced in patent and technology mediation. And of course, there's always the word of mouth and recommendation. I think it's standard practice that when you hear about potential mediators, you run those names by your colleagues within the firm, within your friends, with people you trust their opinions, and figure out what the reputation of the mediator is in the community. Let me turn to Harry now.
Thanks, Rod. When you consider the mediation process in the context of a patent and technology case, it's very much akin to that in a general commercial case or even other kinds of cases. And we're going to, during the course of the webinar today, we're going to dig into some of the specifics here in the slide, but I just wanted to mention a couple of things that kind of stand out in patent and technology cases. One is the pre-session discussions. In particular, those that often occur after the submissions, after you've exchanged submissions, the parties have pre-mediation session submissions, as well as ex parte submissions when you're providing, each party is providing to the mediator an ex parte submission. And it's at that time that it's really worthwhile to have ex parte calls with the mediator for a number of reasons. But one thing in particular is because of the complexity typically of these cases. To ensure that the mediator is already thinking about and has a deep understanding before you get to the in-person mediation session of things like the technology, if that's key. In a contract case, it may be important, but may not be key to some of the issues that come up. But it could be the technology, it could be the infringement, claim interpretation issues, invalidity issues, discovery issue, damages issues that can all be very complex in patent and technology cases. It could be that the mediator needs to understand, is this going to be a global settlement? Are there cases pending before the ITC, a district court overseas, or implicated even if they're not pending? What about the parties? What's the relationship? Relationship issues are important. Are the parties divorcing? Is this going to be it? Or are they going to be continuing to work together? Is there a chance that the parties, even if they're not working together, might have a relationship as a result of the, a business relationship? So those are all things that the mediator ought to know pre-mediation session, in-person session, not at the first caucus. Another thing I'd like to point out, we'll talk about joint sessions later, but I want to point out that I have used joint sessions later on in the proceedings, and that's indicated in the slide. That may not be it may not be solely everybody coming together again for a particular purpose. One example that comes to mind in patent cases is with regard to damages or maybe technology. Let's say there's the parties, it's early on in a case, the parties are reluctant to exchange damages information, but they're encouraged to bring it to the mediation, and in fact, they come with it. Well, it's very helpful to have one party from one caucus go in, let's say the CFO or business person to the other side, into the other side's caucus, maybe to answer questions, to explain. It's a form of a joint session, and it can be used in patent technology cases in a very helpful way. In addition to avoid any misunderstandings that could occur, it's also helpful to build, some trust and confidence, because you never know later on during the mediation that those people may feel comfortable enough to talk again directly. Another thing I'll point out is memorializing settlement documents. Oftentimes in these cases, it's not just a simple settlement agreement. It can be, I've had cases where it's a settlement, it's an assignment, and a license together. It may be if the parties, are going to be going forward in a new arrangement, that needs to be documented. It could be if one party is buying the other party. That's a whole different thing. But the memorialization of the settlement agreements in these cases can take time, and it's often very helpful for the mediator to stay abreast of what's going on and help the parties reach the finish line. And so I'll point that out as something about the mediation process that kind of is unique when you're thinking of applying the typical mediation process in a patent and technology case. Next slide. So we've already talked, Jan alluded to early case assessment. This is a very powerful tool I found, particularly when I was in-house. That's when I used it the first time. Early case assessment can be used in different ways and for different purposes, but for purposes here in getting ready for a mediation, what it does is it helps decision making. It helps you to come up with strategies for the mediation. It's a collaborative process because typically it relies on oftentimes outside counsel, an in-house counsel, or an outside counsel and a business person. at least 2 people, if not more, and I'll talk about that in a minute, to locate important information, collect information, organize and evaluate it. The collection of documents and talking to witnesses is part of the collection of information. Organizing, I think everybody would probably would resonate with people out there on this webinar of how effective it is to prepare a timeline of events. Oftentimes, that's very critical. It can help to strengthen your case or help to show warts in your case. And oftentimes people will say, gee, I remember, I know what happened and when it happened. And it's not until you start to pull documents, you start to talk to people, and you plot out the timeline that things look very different. And the valuation of the information is part of early case assessment, and I'll go into that in more detail in a minute. On the slide, there's a quote, and I really agree with it. Just my own experience agrees with it, which is basically, if you conduct an effective early case assessment, looking at the relevant facts, witnesses, refreshing yourself on the relevant law, and looking at documents, you will probably have 80% of whatever you're going to know about the case. And that's a pretty powerful thing to know, and experience bears that out. Next slide. So this array of goodies are all the aspects really of an early case assessment. Some cases involve all of them. Some cases involve less than all of them. I'm going to, for purposes here, I'm going to just kind of talk about a couple of them. But I want to let you know that one of the things, if you have attended the webinar today, or the one that we're having part 2 on Thursday, you will receive a chapter out of my book that goes into the application of early case assessment principles in patent technology cases. So hopefully that will be helpful. On the left, you see informal fact search. I can tell you as an example, in a trade secret misappropriation case that I had when I was in-house counsel, I propounded about 6 document requests to key custodians and basically got a lot of what would ever be, I would say, important in the case. It caused us to settle the case quite quickly. But that is the kind of informal factual search that you would do. Other facts that you may want to do in addition to documents from key custodians might involve talking to scientists about prior art, on sale bars, things like that. That's another part of factual search, even talking informally to third parties, people who may not be at the company now but were. Business concerns involve all kinds of things. You know, a business person may be concerned that they're, you know, if there's an injunction and they have to stop making widgets, what's that going to do to their business? Will they be responsible for litigation costs? Will they be responsible for damages? Thinking about, well, gee, you know, I know in a mediation, there's oftentimes an exchange of value. The business person can really be helpful in coming up with settlement strategies and options, and maybe an exchange of value that you don't know about, but that person knows about. I'm going to skip to relevant law just to say, again, an early case assessment is really a serious thing to do, because when you're settling a case and disposing of a case for a certain amount, it can be a big deal for a company, any size company. And oftentimes you may be going to higher ups in the company, so you don't want to conduct it by the seat of your pants. You want to make sure that you are up on the relevant law, recent pronouncements, and apply that law, and that you have something in writing that you can give to you know, some of the folks that you are working with, the business folks and others. I will tell you that when you look at the slide you will see that on the left side of the slide, for the most part, you're really kind of digging up a lot of information, good information that you need for the right side of the slide, for your cost benefit analysis, figuring out settlement value, settlement strategy, And so that's how, and what an early case assessment generally is about. With regard to pre-litigation plan, one other thing. So suppose you don't settle the case in the mediation. What you know, as the other slide said, you'll know 80% of what you need to know. So that other percentage of information that you may not have, that you'd like to have, might be, it focuses you. The early case assessment will focus you on what you need if you're going forward in litigation to be able to get in discovery early on. Next slide. So I'm going to start. So in the next slide, we're going to be talking about who it is that, there we go, who it is that's involved in the early case assessment. And it can be any number of these folks, depending upon the size of the company, the business, and depending upon the complexity of the case. Certainly, you may be talking to scientists if it involves, to dismiss the case or resolve the case, you're dealing with a design around, or you're dealing with issues such as I said, prior art issues. The business folks I kind of already covered in the other slide, so I'm going to skip to finance. I became very close to the finance people in the two companies that I worked in because I went to them quite frequently in helping me work on damages issues and applying damages theories. The CEO and board, how are they involved? Well, oftentimes in smaller companies, they may be at the table. I've had the CEO and I've had the chairman of board at tables in a mediation. But if you're with a larger corporation, they may not be involved directly. But if you're talking about selling a part of a business, I've been involved in that before, where you say, gee, we really don't need this part of the business. It hasn't been very productive. I think we're going to get rid of it. Well, you may need higher ups to bless that. Or if one company is buying the other business, that might be another reason that folks at that level get involved. I'm going to skip over investors for a minute, go to insurance. You always want to make sure that see whether there's any insurance that is covered in the dispute or indemnification. I've had cases before where my client was a deep pocket. They bought the infringing widgets from somebody else. We go back and we look at the agreement, and lo and behold, there's indemnification that will help us out. And other licensees come up because you may be that there are other license agreements, if it's a patent-related dispute, where the licensees have said in the license that, gee, you can't offer such and such of a deal to somebody else unless we get crack at it first. So that's where other licensees may come in. With investors, best to last, because investors can complicate the situation. An investor can invest in a smaller company, in the patent portfolio, in the business, and they are investing in the whole thing. And the party may say, gee, I think that we can settle this case easily by licensing the other side for this geographic territory, or these kinds of products, etc. And the investor says, no, you don't. That may be easy and expedient for you, but I invested. You're taking away some of the value. So my only word to the wise would be to make sure before you go into mediation that if you have an investor or investors, that they are apprised of what's going on, and that if they are going to in any way affect a range of things, options for resolving the case, that that in advance. That's it for ECA for now.
Okay. Thank you, Harry. So building on the ECA learning, I have a couple points to raise in terms of formulating a strategy at this point for the mediation. So one with the ECA, first, we'll focus on the scope that the mediation and a potential settlement might look like. Second, looking at the content, what might be in that settlement. And then thirdly, looking at some of the logistics of making the mediation work for you. So first, in terms of the scope, really having done the research to assess what are your BATNA and your WATNA, which the lingo from getting to yes some years ago. BATNA is the best alternative to a negotiated agreement, and the WATNA is the worst alternative to a negotiated agreement. So those assessments are going to give you a sense of where the boundaries are in terms of what does a possible settlement look like. Ideally, you want to have a sense of your BATNA and WATNA and the other parties' BATNA and WATNA, and those will be the boundaries around any zone of potential agreement. Really probing the interests and the needs and the concerns, both from your client's standpoint and the other party's standpoint, because those are the building blocks for putting a settlement together. And then, as Harry already mentioned, is thinking about what is the scope of this settlement going to look like? Is it a global settlement? Does that make sense? Are there other suits pending and proceedings? Are there international cases and proceedings that we need to be mindful of? Does it make sense to in terms of your map of the interests and parties? Does it make sense to pull it all together here, or do you want to parse out piece of this for separate resolution? Structures, what is the content of the settlement? Does it involve payment of damages, licensing, cross-licensing? Are there some creative business arrangements that can really, the parties can develop, and that would give you more flexibility and more potential value in the resolution? So next is to give some thought to the mechanics and logistics of the mediation. Certainly in current times now, we're much more mindful of the option and perhaps the preference of doing an online process as opposed to in person. If we shift online, we have just modest mechanical pieces that we've been dealing with for the webinar. For a mediation, a lot of moving parts, both technical and human. So thinking about, does each party have a secure connection, working camera, no hurricanes blowing through, a mic and a speaker, make sure the software works as you think, become proficient with the software. And this means that if the parties and counsel are in separate locations, is there technical support for both to make sure the participants are secure in their location and in their communication with the client and lawyer? Getting your signals straight, make sure that you've conferred on who's going to take the lead on which issues, whether there are documents. So on share screen, are you going to have a PowerPoint? Who will share the screen? Who will manage it? And how will this all happen mechanically? And emergency in case of, to make sure that you have cell phone connections to back up with each other across the table and on your side of the table. The scope of the confidentiality in mediation absolutely is quintessential to the mediation process, but you want to make sure that you're on the same page. So there's confidentiality, both in terms of the whole mediation and in terms of the caucus, the private caucuses. So for the whole mediation, if you're in California, you'll be familiar with the evidence code provisions on confidentiality and admissibility. And most likely you will have a confidentiality agreement that has been, lays out the specifics of expectations. In the caucus, there is a presumption of confidentiality in caucus, and that is called Las Vegas rules, but that's rarely used now. So the presumption is instead of no confidentiality from the private caucus to the other party. So a presumption that what the mediator learns from the parties in counsel in the private caucus can be shared unless the party or counsel said, this is confidential, do not share this with the other side. So to making sure signals are all straight and it's clear between the client and the lawyer and the mediator when they meet. Thank you. Let's see. Okay. Rod, do you have a polling question for us?
I do. Hopefully it's going to come up here.
Okay.
So we're shifting now to applying what we've been talking about for the last, going on an hour now, I guess, to our fact scenario. So here's the question. From defendant Coe's perspective, what are the potential advantages of having a joint session? A, an opportunity to speak directly to the client decision makers for PL and provide a realistic liability and damages analysis. B, simply meeting all of the players, the lawyers, the client representatives, and the mediator in person or by Zoom, as Jan has explained, before transitioning to private caucuses. C, listening to the unvarnished views of PL directly, which could provide a better understanding for DEFCO of its opponent's underlying interests. D, PL's presentation at the joint session, including statements by any potential witnesses, could provide DEFCO with valuable information about the strength of PL's case. Or E, all of the above. Please go ahead and put your submissions in. Give everyone a chance to weigh in. And here are the results. I guess the answer was kind of obvious here. 88% of you said all of the above, and I think that's probably the right answer. Any one of the four possibilities certainly could be justified as a reason for having a joint session or limiting it to only introductions. I think all four of those options are illustrative of the potential use of joint sessions at mediations. And let me switch to a little more depth in this. There we are. So these days, joint sessions are less fashionable than they once were. It used to be that you'd go up to a mediation and every mediation would start with a joint session, meaning everyone's in the same room. Typically, lawyers would say their piece, like opening statements for each side, and there would be a kind of a formulaic thing to it. Oh, I'd say in the last 15 years or so, that's gradually fallen out of favor. So now I think it's true that most, if not many, mediations dispense with the joint session. So if you show up in person, you're often just shepherded into your caucus room where you'll meet with the mediator, and the mediator goes back and forth. The Zoom mediation is an interesting dynamic because I think joint sessions may be more common in Zoom mediations. There is the tendency to start all in the meeting room together. They may not last long, but that's more of a natural start to the Zoom mediation. Although you can, if you'd like, arrange it so you go directly into the breakout room and never see the other side. We've talked about advantages and disadvantages with that polling question. I think that it really depends on the situation. It also depends on the personalities of your clients and the other side. If it's going to be counterproductive to put two people in the room, you probably don't want to do it. So the point is the approach to a joint session is critical, and you need to plan that out in advance. You need to think it through. Do we want a mediation? Do we want a joint session at this mediation? Do we want to do opening statements? Or do we just want to do introductions? Or do we want to, as Harry suggested, hold the joint session for later? Wait till the damages guys get involved and that becomes important. So the joint session is a flexible piece and a tool that can be used in mediation to meet your needs. That pulls over to a related topic about, well, who should show up for your client? Who shows up may affect whether or not you want to have a joint session. You might want to have a technical expert if the case is really technical, or a legal expert, or both. Someone who can walk you through the technology and explain it to the mediator. Or you may want to have someone who's very good at negotiating and has had lots of experience, perhaps even with the other side's team. You of course want to have people who are available. You're not going to be there if they're not available. And you're going to want to have someone with authority. Most courts make this express. Most mediators make that express. It doesn't do you much good to bring people who can't speak for your client and can't bind your client to a resolution. And last but not least, that word temperament, I've mentioned it before. If you're going to meet with people in person in a joint session, you're going to want to have someone there with the right temperament. That could be the protagonist in your dispute. It could be someone who has firsthand knowledge, or it might be that protagonist is someone you don't want to bring to the mediation, and you're better off bringing someone with a different personality and skill set. So again, the answer overall is it depends. Let me shift now to Harry to talk a little bit about getting your client ready.
So in getting your client ready, I would ask you to superimpose the list here onto the earlier depiction, if you remember, of the mediation process. And the reason why is getting your client ready takes time, and it can be done over time. The first thing that you need to do to get your client ready is to make sure, to the advocates out there in the audience, that you're ready. And that's really important because you're guiding your client through it. Your client or the client representatives who will be there are probably pretty busy. And maybe they've been through the mediation process and maybe they haven't. But there are times along the way, starting from the beginning, starting from the time that you're choosing the mediator, as we mentioned, what kind of what's the process going to look like? What will will there be joint sessions? Will there be, the breakout sessions? What to expect? All of those things are things that you're going to be bringing your client up to speed. And part and parcel of that is making sure, and the last bullet on the screen is create a driver, not a passenger mindset. You want to make sure that the client representatives are digesting the fact that this isn't, they're not attending a summary judgment argument or a Markman hearing. They're attending something where they're going to be participating, and they need to be prepared for that. And so part of that also would include the submissions, making sure that they're part of preparing, maybe not the exchange submission, it's a little bit more legal oriented, but for sure the ex parte submission. And the other thing I'm going to mention quickly here is something that occurred to me. Was in my last case that I handled when I was in private practice, and it involved a smallish company, and it was the chairman of the board and the president of the company. These are very busy people. They traveled all around the world, but it was a very important case to them. And I made sure that before, they were coming from Belgium all the way to California, I made sure that they realized the importance of spending time with me before, because things like we've already mentioned it, BATNA, things like objectives, things like that, a realistic BATNA and objectives can change over time. They really can. And in these kinds of cases, in patent and technology cases, so many different options can oftentimes available that you need to think these things through, and oftentimes people do them iteratively over time. And so my parting comment for this slide is, don't wait to get your client ready, the night before over dinner and drinks, or the day of at the breakfast. Make sure that it happens thoroughly and before. Next slide. So the next thing is, we've got a polling question. Okay. All right, here we go. To get ready for a mediation, which of the following should the representatives from PL Industries and DEFCO who will be attending the mediation do? A, leave sufficient time to meet with their counsel to understand what to expect at the mediation, including their level of participation. B, review the submissions their counsel will be providing to the other side and the mediator. C, have on-call people with authority or information, like scientists and senior business personnel, CFO, investors, etc. D, help their counsel gather information that might be useful at the mediation, or E, discuss with their counsel a decision tree analysis. What do you think? Okay, so very good. Okay, actually, we probably could have had all of the above. 89%, because of my emphasis, and I really do mean that, certainly we're right on point. The others are the other people are right too. Everybody's right. It's one of those things, because all of the other things are really very important and are part of preparing your client for the mediation. Okay, next slide. Next, we're going to talk about preparing the mediator for the mediation. And again, I'm going to refer back in your mind to the slide that has the mediation process, because again, it's an iterative process in getting the mediator ready. Some of the high points, of course, are going to be the mediation submissions that we'll talk about and the pre-mediation calls with the mediator. Again, and sometimes in patent and technology cases, there may be, if the case is ongoing, if this is an ITC mediation before the International Trade Commission involving investigation, your pleadings are going to be very large and very fulsome. And that may be all you need from the standpoint of getting up to speed on the merits. Or there may be if it's in a district court, it may be Markman hearing or summary judgment that's been filed. But keep in mind that those can be selective issues. And if one of the purposes in the case is to inform the other side, here's what we think are the strengths of our case and the weaknesses of your case, having an exchange submission can be very helpful to do that. But I like to spend a little bit of time on the ex parte submission. That is that submission that the party submits only to the mediator, because that, to me, that's where the rubber meets the road in many regards. As I've alluded to already, patent and technology cases can be very complex. Not only the merits and all the different moving parts, and if you think about David's, the case that David recited earlier, there are patent issues, there are damages issues, there were trade secret issues, confidentiality, maybe, confidentiality agreement issues, all kinds of things. And when you have that, not only are there those issues, there's the business issues, what's going to happen to the business. And then there's also there are people that don't like to think that they consider the other non-merits issues to be touchy-feely issues. But relationship, trust, things like that, the future of the parties. Oftentimes in these kinds of cases, the parties have gotten together because these collaborations are, if it's not a patent infringement case, the other kinds of cases, there can be collaborations that are very valuable to each party. And so there's oftentimes information that really, behind the scenes information that's very helpful to the mediator that only comes forward in the ex parte submission and in phone calls, the ex parte phone calls. So my word to you, the takeaway is, when it comes to the ex parte submission, don't use it as another opportunity to argue the merits. If the mediator has given you the list of issues to cover, do cover those. Okay, it's really very important. And the other thing, and don't leave preparing the mediator to the morning of the mediation. Okay. The other thing I'll tell you is on the slide, you'll see other documents in the tech case, and there may be all kinds of different things. There could be expert reports or surveys, the copyright, even these issues can be part of patent and technology cases. Those all may be important if they involve key issues in the case, and the mediator wants to get up on what these issues are in terms of being able to reality test or probe. So that's just a little bit about getting the mediator ready.
Okay, so a little more about planning the mediation session itself. You are going to want to use the information that you got from your early case assessment to develop your negotiation strategy. Again, you probably are going to be wanting to look at a global settlement if it's the type of case that involves more than one jurisdiction, more than one issue. It never makes a lot of sense to settle one case somewhere and then have the same dispute going on in parallel, perhaps about different patents and products, but really sort of an extension of the same thing somewhere else. So be prepared to do that. You will want to get very specific about what you may be putting in settlement agreements. You know that if you're going to settle the case, you're going to have to be able to quickly reference patent numbers, applications, if there's a post-grant review, what's going on there, understand what's going on in foreign cases. If the case involves trademarks, you'll have to be able to have at your fingertips registrations and descriptions. Same for copyrights. Our case that we have here involved trade secrets and products. You'll need to be able to find some way to write out definitions of what's allowed and what's not if there is some sort of agreement as to what people can and can't do, or if there's a license of some sort. That's not something you're going to be able to do on the fly at 7 o'clock at night after you've reached sort of basic agreement. And yet you don't want to leave your mediation session without something in writing that's specific enough so that it is possibly enforceable. So you'll really want to have all these sorts of things at your fingertip. If you think there's going to be licensing, you need to know what the rate is, how to define that, how to define the base. And then in many jurisdictions, there is magic language. We'll get into this more on Thursday, but there are magic words and statutory references that you'll want to have at your fingertips, depending on the jurisdiction, to make sure that your any writing that you come up with is enforceable in the future. Now, in many IP cases, tech cases, it's just going to be a little too much to expect that you're going to finally reach agreement at sometime, at night and really get everything written down. But you really do want to get as much written down as you can. People tend to have buyer's remorse the next day. And you want to get enough written down so that the basics of your settlement are there so that someone's not going to backpedal the next day. A great idea is you probably have an idea of what a settlement could look like. Draft a sample settlement agreement with a lot of these details in it. You don't have to show it to the other side. Use it as a checklist, and you can use parts of it if you need to. So that's very nuts and bolty about planning, but just reaching a settlement in principle is not enough. You're going to want to have enough details to make it stick. Let's return now to the case of the lost licensee and think about how we're going to approach the mediation session itself, thinking about damages and remedies. Here are some of the numbers. What PL knows is about 300 machines have been sold, 13.5 million at a 10% royalty. That's 1.35 million. In royalties, they certainly think is owing. PL also thinks that but for this infringement, it would have made 75% of the sales that DEF made. I'm not sure why it thinks that. It didn't have a survey yet, but it really thinks that's probably that its software really drives this stuff. So that's another 3 million in profits it thinks it lost at its margins. Also, it's incensed about the trade secrets they think Ms. Arnold took from them. They think that there should be a disgorgement of the sales at 30% as a margin. That's about $4 million I think they get back. They think punitive damages are in order, treble for the patent, double for trade secret misappropriation under the law that applies. They also think they should have their attorney's fees. They've been about $250,000. And they've got about $75,000 in costs, which shows you this is pretty early on in the case, but it's still some change. In terms of the defenses, this whole data flow thing is a little unclear, particularly if this is going to a jury. That might be a little problem, but they're pretty clear that the invalidity on the abstract idea is a non-starter as a defense. The DEF, as the defendant, has the same numbers as PL. Yeah, they understand that at 10%, if they lose, that's 1.35 million in royalties. they don't think, the management doesn't think they should be paying on the whole system. That doesn't make sense to them. They think they should only pay on the software, so they really think they should be paying less than this. Their counsel's not quite sure about that. They are convinced of their non-infringement defense, but they realize that could go either way. The other defenses they think might have some merit if data flow is not construed narrowly. They don't think, though, that the 101 defense is any good. And they really think plaintiff's trade secrets case is weak, particularly in terms of getting damages, because after all, everything was licensed to them for 10%. So they think that's really the ceiling on almost everything. With all that in mind, and anything else you've written about this case, let me ask these couple of questions. What should PL's initial monetary settlement demand be? A, the whole enchilada, that's everything, lost profits, lost sales, any royalties on the rest, disgorgement, trebling, doubling, everything, attorney's fees. So that's $18 million. You know, start high. B, should they go in with everything but punitive damages, costs, and fees? That's $7.3 million. Or should they start at patent damages? That's $3.375 million, just the patent damages, recognizing that there's probably overlap between the patent damages and trademark. Or just a royalty. Let's just get this done going at $1.35 million. That's what you say we owe you. We'll just pay that and have done with it. Or half a royalty, indicating they really want to settle. Or something else. So what do you think? Now I'll give you a minute to go through all that. Okay. Well, so surprisingly, the majority of you came about where I would. Now, of course, you would have done a lot more analysis than we have available to us before going in here. But the thought would be that it seems to me that going in for every single thing as your first demand, that's, by the way, not unusual. But if your first demand in a mediation is, I want everything I would get if I won this case completely, I don't recognize any risk at all, I guess that shows a lot of chutzpah, but I don't know that it really is the right approach. I think B's getting more there, saying, yeah, you know, we recognize that nothing's perfect, nothing's easy. We think we have the better of this case, and here's, you know, we'd like to get this done. Here's a reasonable amount. And of course, depending on other things, you know, maybe a little something less would make some sense. But I think, you know, you want to go in, it seems to me, having seen a number of these, high enough so people know you're serious and believe in your case, but not so high that they just dismiss it and say, well, that isn't really a settlement offer. That's just, you want everything. We had another poll-in question. Okay. What other issues, knowing now what you know about the case of the lost licensee, do you think should be considered? This is a multiple choice. Pick all that apply. A license with different terms, an agreed injunction against sales of this new software, a business arrangement under which defendant's license becomes exclusive, another business arrangement in which DEF will distribute plaintiff's systems, an apology by DEF, perhaps, depending on the personalities and what you learned. I'll let you work that. I'm interested to see what people are going to say. Yeah, I have to agree. It looks okay. It looks like certainly the one thing to look at would be the dissatisfaction. Certainly, the dissatisfaction seems to be with the license. That seems like, from a business point of view, that might be the easiest place to turn. But there are all these other considerations. Remember, in our hypothetical, the plaintiff really kind of needs this relationship. It's important that it have a relationship with the company, and they've sort of had their interests change and so forth. So some combination of these things might well be things that would be explored at the mediation. So thanks for those answers. I think they're all good ones, and I think you've all put your fingers on the factors to be looking at.
Thanks. Thank you, David.
Okay, so I'm left to talk to you about very quickly about some resources. One is the Sedona Conference Commentary on Patent Litigation Best Practices. There's a patent mediation chapter that's very good. And I'm happy to say that Rod Thompson here, who presented today, is one of the 2 chapter editors on that chapter. There are also 2 books. And you can see them on the right side, the front pages of the books. One by David Allgaier, who presented today on arbitrating patent disputes you may be interested in, and the other by me. I'm the editor and an author. And in there, you're going to be getting as I mentioned earlier, the chapter on early case assessment. There are a number of chapters in there on mediation, written from different perspectives, from a magistrate judge, in-house counsel, advocates, something about ITC mediation, and let's see, the mediation before the U.S. Court of Appeals for the Federal Circuit. Those books are published by the ABA Intellectual Property Law section, and if you're interested in them, there's a discount that you can get. There's the discount code, and that discount code is viable until August 31st. The other thing I wanted to mention is, in addition for attending today, and certainly if you attend Thursday's session, you'll get a copy of an article by Rod Thompson that was published in CPR's publication called Alternatives. Many of you may be familiar with it, from April of this year. And the article is called Exploring and Using Business Solutions in Mediation Settlement Agreements. It's a great article, a great read, easy read, very, very practical, and it comes from a lot of the experience that Rod's had. So I hope you enjoy that when you get it.
I have a couple questions that have been submitted already. So first I was going to start with Ektabal's questions about cross-border cases. And so Rod, could you respond as to whether choosing a mediator in a cross-border case would be different than what you outlined? I think Mr. Ball will talk about enforcement on Thursday, but we'll answer part of your query here.
Sure. So the basic approach to choosing a mediator wouldn't change. You still want to get information about potential mediator candidates and evaluate what skills, what attributes are necessary. But in a cross-border dispute, you're probably going to want to have someone who is familiar with the cultures involved, familiar with any idiosyncrasies with the legal issues. I mean, what law will be governing? You probably want to have someone who's familiar with that law and procedure. So it's just a matter of expanding the horizon, asking the same questions, figuring out what attributes and personalities are best suited, and trying to find that person.
Thanks, Rod. Mr. Ball, you also raised a question about the confidentiality agreement and whether the cross-border nature of a case would affect that. I'm sure it does. And I think probably more precise research would have to be done on the enforceability and learning from counsel that have had experience in that country or that culture.
Jan, I'll just jump in a little bit.
Yeah.
Because it's related even within the domestic issue. So if you have a confidentiality agreement in mediation governed by Wyoming law, for example,
Right.
that may not be enforceable. Under California law, it would be. I suspect the same is true with international issues.
Yeah. So yeah, thank you for pointing that out, Rod. So we have said that confidentiality is a cornerstone of mediation, but you can't promise for sure that it's airtight because there are jurisdictions that have made some exceptions.
Well, one other thought I'd give about confidentiality is there's really in terms of admissibility in court, often the things that happen during the mediation are going to be confidential. But in terms of suggesting to somebody questions they might ask, documents they might look for later, all that sort of thing, there's no fruit of the poisonous tree or anything. So things that are raised in the mediation certainly may eventually somehow come out, and a party might use them in getting their case ready.
So I have a question from Paul Mason, and just raising how and when would one look at the interpersonal relationships? And Harry, the question was whether that would be part of the ECA process or whether that would be done in some other way. So maybe you have some comments on that.
Sure. I would say, yes, it would be part of the ECA process. In particular, it may impact who attends the mediation. Have there been settlement negotiations before? Was it the people that got in the way, or were there other things that got in the way? But choosing who attends is part of the ECA process, I think. And another thing I would say that is important, and it doesn't come up certainly in every case, but it's something to consider. I was in-house counsel in 2 companies that were regulated industries, pharmaceutical and telecommunications. And so, the issue was, gee, do we go after party B who's infringing our patents? And we're really upset about that when we may be at the table on the Hill in Washington dealing with other kinds of issues with them. And we're partners. And so again, during the ECA process, it's important to consider other relationships that companies may have in the vein that I just gave, or suppose you're trying to, you're thinking about future relationships with this party. Yeah, all those things I definitely think are part of the ECA process. Absolutely.
Okay. Thank you, Harry. I actually have another question I'm going to slide in and ask you. Ms. Otero has asked, at what stage would parties submit their ex parte submissions?
So typically, I would say what occurs is during the mediation process, once the parties have determined, when they're going to meet in person, when there's going to be an in-person mediation session, and what the process is going to be like, the parties will agree with the mediator about what the submissions are going to look like and when they're due. And that oftentimes can be, I would say, a mediator oftentimes likes them 2 weeks before, but it's also maybe, a week or a week and a half before the in-person mediation session. And you want to leave enough time for those ex parte calls, the follow-up calls that are informed by the briefs, but that are even more informed once you get to talk, the mediator gets to talk to the parties.
Okay. Thank you. Hey, Harry. Let's see, David, I was going to ask you another question from Mr. Ball. Was in your case of the lost licensee, the DEFCO is a Chinese company, so how would you look at the legal sanctity of confidentiality and what provisions would apply?
Well, it really would depend on what your mediation agreement says, number A, and really the cultural aspects of that, which is something that you would have to inform yourself about. One interesting thing is, there's confidentiality that's in mediation agreements, or in mediation sessions, I should say, because that's what the law says. And it says that things aren't admissible and you can't subpoena the mediator and all that sort of thing. Parties can also agree that they will simply keep things confidential. So you can sign a confidentiality agreement like any other confidentiality agreement you see between businesses and otherwise. And it may be that in a mediation of that type, you would want to have such an agreement. Now, enforcing it's another thing, because it'd be a breach of contract. You'd have to figure out where to enforce it and how. And you could probably provide for all that as well in jurisdiction to do that if that was important to you.
Yeah.
But I find in this, actually, arbitration and mediation, often counsel doesn't think quite as hard about confidentiality as they really might want to, and address that in the agreement, and even an agreement between the participants, if that makes sense.
Okay. Thank you. Let's see. I have a question from Haku Khan, and let's see.
Actually, Janet, the question from Mr. Khan, I think it's a Mr., I hope so, or please correct me, relating to the technology. I hate to do this, but I think it's appropriate. I'm no longer the chair of the section of dispute resolution of the ABA, but I can tell you that I know that the ABA is planning, and I think it's already been advertised, beginning to be advertised, a webinar that will present vendors, not only Zoom, but all kinds of vendors for use in mediations, technology. And you pay some very modest amount, and then on a platform, you're able to visit and talk to them. That is, for the time that we have, that's probably my best response, but a very timely one. And if you, for any reason, you can't find it on the website for the American Bar Association section of dispute resolution, send me an email and I'll try to get you the link. So I hope that that's helpful to you. It should be.
Okay. Thank you, Harry. I have let's see, I have a couple new questions that come in. But Harry, on the books, do you know if they can be shipped to Spain?
I don't know that.
Okay. All right.
I
Okay.
don't know that, but I hope that they can.
Okay.
I wouldn't bet against it. I bet they
Yeah,
can.
yeah.
Okay, and might we again list the 3 books identified a few minutes ago? They're on the PowerPoints, and the PowerPoint slides will be posted soon. Is that right?
Yeah, I think so. Yeah.
Okay.
Oh, there they are now.
Okay, perfect. So you can find the 3 books there. Okay, that's a couple questions. Mr. Smith has raised a question. Is there a concern that the facts given to the mediator and the other party in a confidential mediation are not always truthful? And how do you deal with that?
Boy, I'll have a shot at that, Jan.
Okay.
It's not an easy one. I think, in part you have to look for self-enforcement. So if there is no resolution, and as David has pointed out, the facts themselves that are disclosed in a mediation aren't confidential. That is, you can prove the same facts by discovery. So if you suspect that facts from your opponent are not accurate, that were used in mediation, you have discovery tools to test those facts. You can certainly test the facts and see if they're true or not. You may also, at the session itself, play devil's advocate through the mediator to really just express doubt and skepticism about the accuracy of what's being represented.
Okay.
Unfortunately, it's the kind of thing that does happen. Mediation is like a business negotiation. And I think we're all familiar with business negotiations where certain things aren't as they are represented to be. So that is a concern and something to be aware of, especially that's really more the role of the advocate as opposed to the mediator.
Okay.
Well, I'll give you an example from a mediation I was in. after representing somebody, it was it was a patent dispute. I represented a defendant and a plaintiff. We said, you know, we have not sold more than a few hundred of these products you're suing us about. This whole thing isn't worth what you're putting into it. And it's just, you know, the kind of numbers you're talking about don't make any sense to us because it didn't happen. And they just didn't believe it. So really the result of the mediation is we had a process where we got them the information it was a very early mediation, just as you would through discovery, and gave them the information so it was just as viable as anything you get in court, just to lay that issue to rest, because it was just destroying the whole case. And there may be information exchanges like that possible in any mediation if one side disbelieves what the other side is saying.
Okay. So Bill, I have 2 questions left, but I'm mindful that we are at the end of our time together. So I think I will save these 2 questions and we'll pick them up on Thursday or answer them directly. One was about dealing with the perception of bias after ex parte documents, and the other was whether you should have multiple counsel at the table when jurisdictional issues are addressed. So good questions. We will respond to them in some fashion. And I'll turn it back over to you, Rod, to close this out.
All I'm going to say is thanks to everyone for your patience getting through this hour and a half. And please, please tune in again 2 days from now, same time, same channel, and we will see you then.
Bye. Thank you.
Okay, thanks all.